Petition for injunction or restraining orders in domestic abuse cases. When an arrest is made in a domestic violence case, the police will provide the alleged victim with a domestic violence pamphlet that provides instructions on how to apply for an injunction or restraining order. Yes, even though every case of domestic violence begins with the premise of a no contact order by the first appearance judge, this packet is still given. There's a drive by police, a public policy to instruct the victim on how to apply for a petition of injunction. There will likely be a no contact order in the criminal case. And if a petition for injunction is filed, then there will be an injunction order in the family court. Again, these are commonly referred to as restraining orders. Injunctions can be petitioned for using Florida statutes 741.30 and 784.046, even if no arrest has been made. This is a civil remedy that has serious consequences. The alleged victim goes down to the courthouse and requests to submit a petition. There are people there to assist, however, they are clerks and can't give legal advice. Obviously, if you're the victim of domestic violence, and you want to file for an injunction, you can do so free. There's no charge for it. But you should probably consult an attorney if you need assistance beyond the basics provided by the clerk. Now, talking about the petition. The petition will be reviewed immediately by a judge, and that judge will determine whether or not there's enough evidence to grant the temporary request. If the temporary request is granted, it is valid for 15 days, and a court date is set for a final determination on a permanent order. If the temporary is not granted, a hearing will still be set so you can tell the assigned judge what occurred, and he or she will determine if a permanent order is to be granted. If you are the respondent, meaning the person who's alleged to have committed the domestic violence, you should consult a domestic violence / criminal defense attorney to represent you in this hearing. Anything you say can be and will be used against you in a criminal case. If you choose not to hire an attorney and speak during this hearing, it can be used against you. If so, it can lead to a criminal charge and possibly a criminal conviction of a domestic violence charge. Listen, folks, if you needed a heart bypass or a stent in your heart, you would not operate on yourself. So don't be a fool and try to represent yourself in a domestic violence injunction hearing, because it usually backfires. If the injunction is granted, you will be prohibited from having contact with the petitioner, the person who is alleged to be the victim of the crime. The time period of how long that injunction lasts depends on the facts of the case and the judge's ruling. Injunction orders can be permanent injunctions, meaning life or until the order is vacated, or for such a short time as 3 months. That is why you hire a domestic violence lawyer. If the order is granted, you will not be able to purchase a firearm. You will lose your concealed weapons license. You will have to surrender any firearms you have to the police. You will have no contact with the petitioner / victim or be in any location that they're in. That means you can't go to an in-law's house or you can't go to their job. An injunction can interfere with your ability to see your kids, as it is used in child custody cases to prevent visitation or cause your visitation to be supervised. Background checks will show a domestic violence injunction, and they're usually, although the court has a provision to seal them, most judges will not allow it to be sealed. Now keep in mind, if an order is granted, right, and you fail to adhere to the judge's order of protection, right, the injunction order or the restraining order, it is a crime. Under Florida statute 741.31, violation of a protection order for domestic violence is a first-degree misdemeanor and is punishable by up to a year in the county jail. So folks, take this seriously. Hire an attorney.